Star Citizens and Crytek's lawyers are engaged in a legal battle over the use of the CryEngine in Star Citizen Squadron 42's development, and the parties there have now jointly put in for a protective order for the Crytek v CIG lawsuit regarding any discovery that might take place. During the discovery process in a trial, the parties request a lot of information from each other that must be provided, like emails, memos, game code. We'll go over more specifics of this in a minute, but this can go back many years, and obviously some of this data is very confidential, and if the case does not settle in the near future, then this process is going to start. Recently, Crytek were ordered to pay a $500,000 bond, which will need to be paid by the 21st of August for the court case to continue. This bond is for the express purpose of protecting CIG and their fees during the defense of this trial, should they become the prevailing party. But now they're moving towards this protective order and sort of defining exactly what is protected and what is not protected, because they don't want sensitive data and information exposed all over the internet to people like you and me. Let's take a look at what was said and requested. I'll summarise where possible. Also, I'm not a lawyer, and this is my understanding of the case and the documents filed, which you can find the links to down below, and you can follow along at home if you would like. Discovery in this action is likely to involve production of confidential, proprietary, or private information for which special protection from public disclosure and from use for any purpose other than prosecuting this litigation may be warranted. Accordingly, the parties hereby stipulate and petition the court to enter the following stipulated protection order. The parties acknowledge that this court does not confer blanket protections on all disclosures or responses to the discovery, and that protection it affords from public disclosure and use extends only to limited information or items that are entitled to confidential treatment under the applicable legal principles. The parties further acknowledge that this stipulated protective order does not entitle them to file confidential information under seal. Basically, the parties can't just file everything under seal and say we don't want anyone to be able to see this. There are standards to meet, and they must ask the court permission in some circumstances or whatever. But it also is down to the parties to look at the information and go, well, this shouldn't be protected, or this should be protected. This action is likely to involve source code, customer and pricing lists. Actually, that particular statement, that looks like it's actually been written by Crytek. Maybe this document was written by Crytek for the most part. It looked like it was written by both parties though. But the customer and pricing lists, that's the sort of thing that maybe it would be needed if they were trying to work out potential damages or something, how much CIG had earned because of Crytek's involvement and how much they were wronged, and they could work out how much Crytek were owed, that sort of stuff. But some of this information that's being requested is just being requested to be burdensome, to leverage a position so that Crytek can get a larger settlement potentially. They also listed here licensing agreements with third parties and other valuable research, development, commercial, financial, technical, and or proprietary information for which special protection from public disclosure and from any use other than prosecution of this action is warranted. Because of the nature of the material that could potentially be shown, that they don't want, customer price lists getting out, they don't want all the details of their customers, all that sort of like protected data, stuff that needs to be protected under GDPR, all that sort of stuff as well, including, I suspect, that Crytek don't want all their financial information getting out there in the same way that CIG probably don't want all their financial information and exactly all the inner workings of stuff that they've done correct or incorrect or whatever. But this information is required by both parties so that they can prepare correctly for the trial. They can find out if, for example, if there was internal memos from CIG saying, let's just switch to the Lumberyard Engine even though we're not actually going to change the code in the game. Something like that, a smoking gun, that's the sort of thing that Crytek might be looking for. Although these protections are not unlimited, they are only supposed to be used for certain things. So the protection conferred by the stipulation and order cover not only protected material considered being confidential, highly confidential, or confidential source code, but also any information copied or extracted from protected material, all copies and excerpts, summaries, or compilations of protected material, and any testimony, conversations, or presentations by parties or their console that might reveal protected material. Any use of protected protected material at the trial shall be governed by the orders of the trial judge. This order does not govern the use of protected material at trial. And even after the end of the trial, those obligations that the order sort of like imposes will remain in effect until a designating party agrees otherwise in writing or a court order otherwise directs. So even after the trial and everything, it's unlikely that we will know anything about those sort of like protected materials. Each party or non-party that designates information or items for protection under this order must take care to limit any such designation to specific material that qualifies under the appropriate standards. So basically, they don't want them just saying everything as a blanket statement or blanket term is protected, and it's both parties' jobs to sort of police that, and then if they do see anything like that, they will write to the court and go, this is not appropriate for protective order or whatever. Any party or non-party may challenge a designation of confidentiality at any time that is consistent with the court's scheduling order. A receiving party may use protected material that is disclosed or produced by another party or by a non-party in connection with this action only for prosecution, defending, or attempting to settle the action. Protected material must be stored and maintained by the receiving party at a location and in a secure manner that ensures that access is limited to the persons authorized under the order. So basically with that, they want to limit the amount of people that can see this sort of like protected material, but not to an extent where they can't defend themselves, so only certain people will have access to it, and they'll list everyone that has access to it, and if there's any leaks or anything, then it's down to those parties to protect and sort of like reduce the risk there. Who can see what when it comes down to those protected materials is based on how the material is classified, so confidential source code is sort of like treated highly confidentially in sort of like how it's classified as well. The designating parties shall bear the burden and expense of seeking protection in the court of its confidential material, and nothing in these provisions shall be construed as authorizing or encouraging a receiving party in this action to disobey a lawful directive from another court. So if there's any other sort of like requirements or restrictions that they have in place for whatever reason, they still have to abide by that, I believe. If a receiving party learns by inadvertence or otherwise that it has disclosed protected material to any person or in any circumstance not authorized by the stipulated protected order, then the receiving party must immediately notify in writing the designating party of the unauthorized disclosures, use its best efforts to retrieve all unauthorized copies of protected material, and inform the person or persons to whom unauthorized disclosures were made of all the terms of this order. And I believe they need to get them to sign something so that they know that they are bound basically by that. So that's an interesting one, and now you might maybe know why they've got like an evocati at Star Citizen. So the idea is that evocati are NDA'd. What if there was some sort of leak that they needed for this case in the source code or something like that in one of the evocati builds, because sometimes they have like file structures, sometimes they have errant code and things like that leak. Maybe they'd have something that they were working on for integration with like a new Intel or AMD technology which isn't public knowledge yet, and if that was seen by a load of people, then that's sort of like the reason they'd have these NDAs, and it could go to court, and then these people would need to be bound. So they don't want all this stuff getting out potentially. So that was just obviously a little bit of a rant there, but you see my point. Also, it looks like that at the end of this sort of like legal action, if one of the parties requests that they destroy all the sort of like protected materials, they have to do that within 60 days. Council are entitled to retain an archival copy of pleadings, motion papers, trial, deposition, hearing transcripts, and sort of like anything to do with the case, even if it contains protected material, but they have to sort of protect those archival copies in the same manner as if it was a protective order still on them. In fact, the protective order is still on them, and if there's any violation to that, then there are measures including contempt of court and monetary sanctions, things like that, that the court could impose. All of this becomes academic, though, if the parties settle, which is very possible, and in fact, both the parties and the court have recently acknowledged that they're trying to come to a settlement. Also, if Crytek did not pay that $500,000 bond, again, that would be the end of the case, at least in the short term. It depends if that was then dismissed by the judge with or without prejudice. However, if nothing changes, then discovery will start and there will be a trial currently listed at starting on the 24th of March 2020, something I would expect both parties to want to avoid if possible, but since the main meat of Crytek's case has been dismissed already, and with a large chunk of their money used for the bond, they are going to be much more willing, in my opinion, to push for a settlement sooner rather than later before costs mount up and CIG potentially become the prevailing party in this case. And because they sold their engine to Amazon in the form of that Lumberyard engine they have, it really inhibits their ability to prove damages because of that. The fact that the parties want certain documents to be protected is totally reasonable, though. I've seen wild theories from people as to why. From it's all a scam to Crytek have no money and they don't want that to get out to public knowledge, things like that. But what do you think? So do you think that stubbornness has caused this case to drag out longer than necessary, or just lawyers being lawyers has done that? Would you prefer CIG to fight this to the end, even if it costs them more, even if they win, rather than settling now? Do you think that Crytek might have some legitimate reasons to sue? Though, following the case, I find that harder to believe now. It's still not out of the question. Whatever your thoughts, I'd love to hear from you, but please remain civil when talking to other people, and obviously it's not the employees at Crytek's fault or CIG's fault that this case has happened. Hope this was somewhat informative. You take care, and as I said, all the links are down below. Every month we have a giveaway. For August, we are giving away a Drake Corsair bundled with an 8-inch Fire tablet and 12 months of Game Glass. Game Glass makes software allowing you to turn touchscreen devices, like tablets and mobiles, into immersive controllers for Star Citizen. But not just Star Citizen, Elite Dangerous is getting support next, and there's plans for lots more games to support this. You can use Game Glass for free, but there are paid options as well, giving you even more functionality. Please follow the links down below to get more info or to download. I'm still also shilling for NordVPN. If you're looking for a VPN, they are very cheap and have many benefits over free services. They help protect you and your privacy online, but it also makes it easier to access various websites as well. And there's Shadow 2, giving you remote access to a Windows 10 gaming PC of your very own, so that you can effectively turn any appropriate device, your smartphone, a computer, a laptop, whatever, into this much more beefy machine. Subscription cloud services, in my opinion, are the way forward, and for some are going to be very appealing instead of sort of maintaining their own PC. For all of those, please follow the links below or use the code BoredGamer to get a discount. A massive thank you for watching. Please consider liking and sharing this content, as well as pressing the bell icon to get informed when a video goes live. Consider Patreon or becoming a YouTube member too if you'd like to further support the channel. Thanks for watching, guys. Please take care, and I'll see you in the verse.